Good afternoon.
Good afternoon, Judge.
Hi, Judge.
Okay, I'm going to call and my audio went out just for a second, so if I missed something, let me know. Well, I'm going to call the oral argument motions calendar first. It's just one case on Russell Ross versus Anita Turner. Defendant's motion for attorney fees.
Yes, Judge. Ethan Williams here on behalf of the defendant.
Good afternoon, Mr. Williams. Is anyone here on behalf of the plaintiff?
Yes, Your Honor. Dennis Swan on behalf of the plaintiff, Russell Ross.
There you are. Hello. Mr. Williams, are you ready on your motion?
Yes, ma'am.
Mr. Swan, are you ready?
I am, Your Honor.
Okay, I'll be with you all in just a moment. Mr. Williams, how long do you think this will take?
Shouldn't take longer than 15 minutes.
Okay. All right, I'll be with you all in just a moment. Oh, do you need takedown, Mr. Williams?
Yeah, we do take down of everything.
Okay. All right. I have a new court reporter than the last time you were with me. Miss Holloway will send you her contact information in just a
Thank
moment.
you.
All right, on the civil non-jury trial calendar, first position is Synchrony Bank versus Jessica Bonner. I'll come back to that. Maybe it's been dismissed. Second position, Travion Hollis versus Tremaine Moore. Okay, I'm back to that. Amaya Best, Linda Wilson versus Tyleen Early Development. I believe that was continued for mediation, and I'll put that back on the calendar. Uh, Miss Stokes, when did they say they were going to have that mediation? Or was it has not been scheduled yet?
It hasn't been scheduled. They wanted the court to
I'm sorry.
adjourn the mediation.
I'm sorry. It sounds like you're talking in a cup. What'd you say?
They didn't set a date for the mediation.
They did set a time.
No.
Okay. We'll reset it to September 3rd.
Okay.
At 10 o'clock. All right. Position 4, Capital One versus Christopher Ware.
Attorney Markeisha Reynolds for the defendant Christopher Ware.
Hello.
Plaintiff told me that they filed the consent judgment. We just haven't received a fully executed copy, so I just wanted to confirm that you all did receive it.
Let me check.
Okay, thank you.
They did file that. I will sign it and get it e-filed today.
Awesome, thank you. May I be dismissed?
Yes, ma'am. Thank you for checking in.
Of course, thank you.
Okay. And I think that's it. So I need to check on these other matters. Is there anyone present who believe they have a case and they haven't heard it called yet? Okay, I know more than just Mr. Swan and Mr. Williams. I guess that's it. Y'all the only two. Okay, call to check on the Synchrony Bank case and the Trevion Hollis case and let me know what's going on there. And I'm gonna go ahead and start the hearing for the Russ versus Turner. Russell Ross, I'm sorry. Yeah, Ross versus Turner.
Go ahead.
Give me 1 second.
Okay.
All right, Ms. Holloway, you ready? All right, this is the matter of Russell Ross versus Anita Turner, case number 2022 CV 0035. This is the defendant's motion for attorney fees, filed by, attorney who is the presented by Mr. Dennis Swan. Mr. Williams, you may proceed.
Thank you, Judge. This motion comes out of a jury trial which Your Honor heard the week of March 17th, 2025, in which the jury rendered a verdict on March 21st, 2025. The parties engaged in a court order mediation back on January 21st, 2025. After that mediation was unsuccessful, the defense filed an offer of settlement in the amount of $250,000. That offer of settlement was delivered to plaintiff's counsel on February 10th, 2025 by a certified mail. The 30-day time period for the offer to be accepted expired on March 12th, 2025, and it was never accepted during that time period. After the
250,000, you say?
Yes, Judge.
Okay, I'm sorry, you can go on.
Yeah, it was $250,000. The offer of judgment was sent. The jury entered a verdict in the amount of $16,500. The court entered a judgment on the same day in the same amount. We've now filed our motion for attorney's fees under 91168. Your Honor is well aware that when the amount of the verdict comes in 75% or less of the offer settlement on the defense side, that pulls the trigger for the defense side to start to seek and file a motion for attorney's fees and expenses incurred from the date that the offer was deemed denied. In order to make an award of attorney's fees, the court needs to be able to determine the amount of attorney's fees based upon evidence that's provided by the attorneys of their fees and as well as by the expenses. In my brief, I mentioned several cases, but the overall gist is that an attorney fee does not mean the actual amount paid or owed by a party to its attorney, but the value of the attorney's services provided to the party. Attorney's fees is to be determined upon evidence of reasonable value of the professional service which underline the claim for attorney's fees. The party seeking fees shall introduce evidence of hours, rates, and some other indication of the value of professional services actually rendered. In this case, Your Honor, I have provided a copy of an affidavit from myself as well as Elena Howard, who Your Honor may recall was co-counsel during the trial. Those affidavits lay out that our billable hour rate was $160.77 per hour. I present the court that that is a very reasonable attorney fee rate of $160.77 per hour for attorneys who tried this case. I've also attached a accounting of my time, which I used to do billable hours a long time ago, and I provided the court with a typed up version of that, the dates and the task I did and the amount of time I spent doing them. That is also attached to my affidavits. That's also part of the motion. I will not go through every single date unless Your Honor so desires me to do so. So it speaks there for itself. All in all, I spent a total of 94.2 hours preparing this case for trial from the date of the rejection offer settlement at an hourly rate of $160.77, which comes to a total of $15,144.34. Ms. Howard as well provided an affidavit that was supplemented later as she was out on vacation when the initial motion was filed. Her affidavit was supplemented. It also provides the same information, of which mine, she also billed at the same rate of $160.77 that I billed at. She logged 48.3 hours at that rate for a total of $7,765.19. All in total for attorney's fees is, if my math is accurate, would be $22,909.53 that we are seeking for attorney's fees. So that I have established that I have provided evidence into the record of the hours and rates and the time that was spent in order to satisfy that prong of the to be awarded attorney's fees. I've also provided, as far as expenses go, the invoices that were provided by providers. Those invoices include invoices from our expert, Dr. Martino. That amount is listed in Exhibit Well of $8,250. There are court reporter fees from Colette Jackson, the court reporter, Beth Cootie reporting, who handled depositions, and Gallo Legal Services, which also did depositions. That was a total of $4,021.50. There was Trilogy Trial Consultants who handled the videos for us. That total was $946.60. And there was a second invoice for $1,260 as well. I did not do the math on that. I apologize. I didn't add those two numbers together. There's also my client, as you may recall, she had to travel from Florida for this trial. She traveled back and forth on several days, and then she would eventually end up getting a hotel in this area. I provided a copy of Exhibit B, which lists her mileage, as well as hotel fees for having to stay, and her total was $1,494.08.
Do you have any legal authority that defendant's travel expenses is recoverable under 9/11/68?
It is I'm sorry, Your Honor, go ahead. I apologize.
I was just saying under a 9/11/68 attorney fee requested. Do you have any legal authority that the defendant's travel expenses is recoverable under that?
Yes, Your Honor. At the moment, I don't have an exact case on point to address that issue. However, I will say that the IRS code does allow for mileage rates for billables for medical transport, which is a fee that is awardable for plaintiffs when they travel and do medical mileage. I believe that it was 27 cents last year. I don't know what it is now, which is always sought by that side. So that is an authority that is allowed to be calculated. The IRS also allows for a mileage rate to be calculated as well. The defendant had no choice but to travel up here for the case. You may recall she was dealing with her mother's wellness as well. So she had to drive to and from Florida The rate that is billed at is the IRS rate. She's not seeking anything further beyond what the IRS allows to be billed for mileage.
I just don't know that she's allowed to recover any travel expenses on an attorney fee and expenses claim. Like if she wants to take a separate claim with Mr. Ross for that, um, that's one thing, but I don't know if there's any authority to grant that here. And if you want me to do it, you're going to have to provide me some legal authority to that, either statutorily or case law.
Very well, Your Honor. If Your Honor will allow me a day or two to do some research on that, I can address that and see if I can find something for Your Honor.
Okay. You can continue.
Thank you. Uh, the conclusion, so in this particular case, the defense has provided sufficient evidence for the court to determine the amount of attorney's fees that were incurred, also as well as the expenses that were incurred as well in doing this case for trial from the time that it expired. And as I currently state also in my brief, the court is to look toward the reasonable amount of the attorney's fees when it's based on an hourly rate. I argue that the 160.77 is reasonable for a rate of that. Also, when considering the objective incurred when it comes to fees, the issue is whether the hourly fees incurred on the defendant's behalf were reasonable and the value of those professional services rendered by the attorney to be controlling, and not whether the defendant actually paid for those hourly fees. So the purpose of the law is that it is what is billed, not exactly what a client may or may not have had to pay. In this particular case, it is clear that an offer of settlement was offered after mediation. All these 9/11/68s are required to be done under good faith. Georgia adopted a few years back the Florida standard for good faith. That case is the most recent one I have is Coastal Bank versus Rollins, 347 Georgia App 847, a 2018 case. In this, I am unaware of any response to the motion that was filed. So I believe the motion is not being contested as far as whether it was good faith or not. But it was done after mediation was conducted. This was not something that was sent 2 or 3 months after the answer was filed, or even 6 months after discovery. And the case really says that when an offer is made in good faith, rests on whether the offeror has a reasonable foundation on which to base the offer, and that so long as the offeror has a basis in known or reasonable believed fact to conclude that the offer is justifiable, the good faith requirement has been satisfied. In this particular case, as I said, it was done after mediation. I believe at trial, plaintiff accounts had claimed somewhere around $181,000 in medical bills. An offer of settlement of $250,000 would be made in good faith based upon that standard. To that end, and the reasonable basis to support the offer is determined solely by the offeror's own subjective motivations and beliefs. At that time, Your Honor, the beliefs were of that was probably there was probably more medical records. I was not in attendance at the mediation. I can't speak to that it was done, but the mediation did last almost 4 hours. Based upon the mediation certificate that was provided, the mediation certificate is done in front of Attorney Steve Gold, and I'm sorry, yeah, it lasted from 11 a.m. to 2 o'clock p.m. So that would have been 3 hours. So it was a 3-hour mediation back at that time. The amount of the jury awarded was $16,500, which was approximately 7% of the $250,000 offer of settlement that was done. The fees are presented to Your Honor. The amount of expenses are presented to Your Honor. All in total, based upon what is now the total amount of fees is $15,975.18. That includes the travel expenses, which we can always, if those that need to be redacted, we can do that later. The total amount is $38,884.71.
I'm sorry, 38.
I have a total of $38,884.71. as a total of fees and expenses. The $16,500 judgment was sent to plaintiff's counsel's office. Looks like it was delivered back on April 15th, 2025. So that the judgment was paid. With that, I have nothing further other than ask the court to grant defendant's motion for attorney's fees. It has met all parts of the statute and Georgia case law for recovery.
I'm sorry, what did you say happened on April 15, 2025?
That was the date that the $16,500 draft for the jury verdict delivered to plaintiff's counsel
Gotcha. All
because we
right,
had to pay it.
gotcha. Thank you. All right. Mr. Swan, any response?
Briefly, Your Honor, I just as a threshold matter, we're talking about a period of 8 days here. So the specific
Are?
time, yeah. So the time in which the offer expired was March 13th of 2025 to March 21st, 2025, when there was the verdict.
Okay.
So all told, we're talking 8 days, 2 of which were weekends. So we're really talking about 6 days here.
Okay.
So in essence, the defense is asking for an award of $23,000 for 6 to 8 days of legal work, plus $16,000 for 8 days of expenses. When you break that out, it's over, I think about $5,000 a day more if you take out the weekends. And so the court needs to determine what is a reasonable amount for such a short period of time. And I just submit to you that what's being asked of you is not reasonable for the amount of time that we're dealing with. Secondly, Judge, and this is just for the record, I know defense counsel will have citations to the contrary, but attorney fees must be incurred. And that's a specific quotation from their brief. By its very nature, an attorney fee, just like any other fee or expense, is something that is incurred. That's Centennial Archaeology Incorporated versus ACOM Incorporated. And Georgia Court of Appeals has repeatedly said that incurred means what it means in the dictionary: to suffer or bring upon oneself, or to become liable or subject to. And in this case, the defendant, Anita Turner, is asking this court to actually award fees and expenses in large part, that she never incurred. And you can kind of see this because they're asking for the mileage, which I concede she did incur the mileage. It was her car. But everything else, she didn't incur at all. As a matter of fact, actually, all she needed to do to get the defense in this case was to pay her premium dollars to State Farm, which she did. And so other than that, they were contractually obligated to pay her a defense. They gave her a defense because that's what they were required to do. But she has incurred and will incur nothing as a result of this other than the mileage on her vehicle. Also, I noted.
So you don't have any objection to the defense travel expenses that she's requested?
Well, I think that she actually incurred them. Let me just put it that way.
Okay.
I want to be clear. I do not believe she incurred anything else, because I know there's been absolutely no evidence, and there will be no evidence, that she has written a single check for any of the stuff that is being asked of this court to award. She didn't. She paid her premiums. They provided her defense because they were contractually obligated to do so. Okay, I think this is probably the most important, Judge. A lot of the defense's behavior in this case created the need for a large portion of these expenses and fees. The collision occurred in 2020. It was filed in 2022. Dr. Martino, their defense expert, was disclosed September 30th of 2024. And in the disclosure specifically, it said, Dr. Martino's report and other relevant requested information will be supplemented. It was never supplemented, despite a 6.4 letter that was sent. And at the 11th hour, on the 14th, the 13th, the day that the offer of settlement expired and all of this is now being asked to be awarded, we had to take a discovery deposition of Dr. Martino so that I could figure out what his opinions are that were promised to me in September of 2024, but were never provided. And so now the defense is asking you to award fees and expenses for a condition that they created. And it's not a small amount, Judge. If you look at it, It's $7,500 for Dr. Martino on the 14th, just in his time. And then it's another 14 hours, I believe, on the 13th and 14th for the attorney expenses for that. I mean, it totals nearly a third of what's being asked here is something that the defense created themselves. That if they had just done what they said they would do in September and give me the report, I never would have had to take that discovery deposition in the first place. And lastly, Judge, I mean, defense counsel touched on this a little bit. It is solely up to your determination to figure out if the offer that was made a month before trial was made in good faith. And I imagine that there's a knee-jerk reaction on everybody's part to say, well, the jury said it was worth 16.5, so 250,000 is reasonable. But courts repeatedly caution us against that because you are given the discretion to determine if it's good faith. There is no formula for that. That is for you to determine, conclusive of all of the evidence that you heard. And I would just submit to you, Judge, that the bills were nearly $200,000. As you well know, attorneys in my position work on a contingency. We had significant expenses in this case. So $250,000 would not have even covered Mr. Ross's attorney fees. His medical expenses and attorney fees. And so it's up to you to determine whether that is in good faith when it was made. But if the contentions that the plaintiff was advancing were true, and he did have to get surgery as a result of this collision, which he sincerely believed, $250,000 would have been, frankly, a drop in the bucket, Judge. So that's it, Judge. I submit it to you.
Thank you, Mr. Swan. Mr. Williams, do you have any further argument?
Yes, Judge, I wanted to touch on a couple of things. The offer of settlement is not required, at least I'm unaware of any law that says an offer of settlement has to include the fees that an attorney may or may not recover in a case. The offer of settlement is done based upon the evidence of the plaintiff's injuries and claims. The plaintiff's claims and injuries were the surgery was mentioned, things that were presented at the jury trial, his medical treatment, so forth and so on. The $250,000 would more have covered his medical expenses and been on top for pain and suffering as well. I'm unaware of anything that says that when offer settlement is done subjectively, the person making the offer has to consider the amount of fees an attorney may or may not recuperate in a certain amount. I'm not aware of that at all. Like I said, the good faith offer is based upon the subjectiveness of the offerer when it is made. The rigmarole dealing with Dr. Martino and the report and everything, I can't speak to that because I was not around for that part of the case. But it was argued may have been argued on the record, I don't know. But if plaintiff's counsel had an issue with all that information, he could have filed an appeal. Or filed a motion rejecting Dr. Martino's amount of his things, or things like that, things that are argued. No appeal was filed. Whether or not there was any type of what went on before the offer of settlement was filed for the purpose of this court is irrelevant. What is relevant is that the offer of settlement was made pursuant to the statute. It was made in good faith after mediation occurred. The offer of settlement well exceeded the amount of medical bills. It was for $250,000 that the offer of settlement was made for. And the offer of settlement was not accepted. At any time during the trial, at any time did anyone come to us and ask, hey, is that offer still available? Can it something that can be worked on? No one ever came to ask about that or even approach about that consideration at no time. So the fees were respected. Now, as far as the 8 days, yeah, you're right. It was 6 or 8 days, and I worked my butt off. I have provided a list of all my time that I did, and I provided an affidavit with my time log. As a former billable hour attorney, I know how to keep track of hours. So that is what I billed. All these bills, all these things that I made from the 13th, the 14th, the 15th, I spent the entire Saturday working on this case, preparing for things. I got up at 6 a.m. I was at this office by 7:30. I worked all the way into the night on that Saturday. I worked on that Sunday. And that Sunday stuff was only short because I had tickets to the Atlanta United Miami game that night, which I went to because I had already bought them a long time ago. So to say that just because the amount of fees was incurred in short amount of time is not relevant either. What is relevant is that you have a factual basis which to award fees. I have provided that factual basis. It has not been challenged. No response was filed challenging my time, my entries, or my hours that were billed. No response was filed challenging my hourly rate of $160.77. You have all the time that I have provided to your honor of everything that I've done. Yes, it was 8 days, but it was a very long 8 days and very painful 8 days to do this trial. There was also some discussion about fees being incurred. That is not what the statute says. The term attorney fee does not mean the amount actually paid or owed by the party to its attorney, but the value of the attorney services provided to that party. All right, that is from Centennial Archaeology versus AECOM, which Plaintiffs' Counsel cited, which was discussed by the Supreme Court in Blanchard versus Bergeron, also in Bloom versus Stinson. The case of Couch, which is Georgia Department of Corrections v. Couch. The citation is in my brief for your honor to see. It states that, if I can find the quote here. Yes. Thus, when considering the adjective incurred as it relates to attorney's fees, the issue is whether the hourly fees incurred on defendant's behalf were reasonable, and the value of those professional services rendered by the attorneys to be controlling, and not whether defendant actually paid those hourly fees. 295 Georgia at 485-85 is the pinpoint site. My knowledge, that is good law. So whether the issue is not whether anybody paid anything, the issue is were those fees incurred. There was no evidence in a response motion provided to your honor regarding State Farm's obligation to provide counsel or anything like that. There was nothing provided in any time response brief. So that end, I submit that the defense has met its burden. It files the statutory controlling offer of settlement. It was based in good faith after a mediation had been conducted after many years of litigation. It was for $250,000. The jury came back with a verdict of $16,500, well below the 75% threshold. The reasonable time and hours have been provided. The invoices for all the expenses have been provided. Good faith was achieved based on this, and your honor has been provided all the information in order to award a total amount of attorney fees of $22,909.53 and expenses of $15,975.18 for a total of $38,884.71. Thank you.
Thank you, Mr. Williams. All right, that I will try to get an order to you all by the end of next week, but with the holiday, no, that's not next week.
The holiday's Thursday.
Well, the
Tomorrow.
holiday's Thursday. I'm thinking about the
Tomorrow.
4th of
Yeah,
July.
yeah, yeah.
So I'm skipping ahead a little bit. So hopefully before July. I'll say
Thank
that.
you, Judge.
All right.
Thank
Much
you,
appreciated.
Ben.
Good to see you.
You all are excused. Thank you.
Thank you, Your Honor.
Mr. Swan didn't even bother putting on a jacket for that. Okie dokie. Miss Leverett.
Yes, Your Honor.
Hello. Who are you here for, ma'am? Yeah, I can't make out what you're saying. I'm just gonna come to the courtroom, okay?
I am where?
Just come inside the courtroom because your connection. I can't hear what you're saying. I'm just gonna come back in the courtroom. All right, Miss Holloway. I don't know if you heard me, but we're we're done. I'm gonna shut it off.